Hey, everybody. Welcome back to Thursday night. John Skiba here on the Consumer Warrior YouTube channel, where each and every Thursday night we do this live stream where we talk about all things debt related, whether it's bankruptcy, debt collection lawsuits, wage garnishment, or any of the other horrible things out there. We talk about it. Again, my name is John Skiba. I am the owner of I always get it wrong, Arizona Consumer Law Group. I'm a practicing attorney in the state of Arizona. And that's really what I do. Most of my law practice is focused on helping people with consumer debt issues. Specifically, I deal with Chapter 7 and Chapter 13 bankruptcies, and I defend debt collection lawsuits. We're going to talk a lot about that today on the live stream as far as if you're being sued by a creditor, maybe some different approaches that you can take. And I can kind of walk you through that process in general. And I can show you where I see people make a lot of mistakes. I've done a lot of these. I've been practicing law for almost 22 years now. I've done over 200 trials against debt collectors. I've argued cases before Midland Funding, before the Arizona Court of Appeals. I've done a lot of this. I've met with, I said that and actually figured out, I think I've met with almost 15,000 families talking about debt-related issues. And so I can kind of let you know my thoughts and approach to it. Now, while I am a licensed attorney, I'm only licensed in the state of Arizona, and I am not licensed anywhere else. And so you can take this for what it is. It's not legal advice. It's some guy talking on YouTube, and it is what it is. If you are in the state of Arizona and you need help, I put a link in the notes there in the chat section where you can actually schedule a consultation. You'll talk with me, and I can kind of give you some guidance and even take on your case if you're in Arizona. However, if you're not in Arizona, there'll be another link in there. You can click on that, and I can connect you with an attorney in your state that does what I do. And before we get into it, I want to also thank Solo, who I've been on their channel. They've been on my channel. Great sponsor of the weekly live stream. They have some awesome tools to help you to settle debts, even respond to debt collection lawsuits, which we're going to talk about today. And head on over there. Like I said, it helps the channel. It'll help you. They do a great job. So the way that we do this each and every week, if you do have a question, go ahead. If you're on YouTube, put it in the chat. If you're on Facebook or on X, go ahead and put it in the comments. I'll put it up on the screen, and I'll give you my thoughts on it. So I want to talk about debt collection lawsuits. Like I said, I've dealt with these a lot. It's not just theory. I've represented clients. I've gone to trial, arbitrations, both in the courts. I've done arbitrations through like American Arbitration Association. I've been through the entire process. The number one thing that people do incorrectly when it comes to debt collection lawsuits is they don't file an answer. Now, the way that lawsuits work is the creditor files the lawsuit, the complaint, and then the court gives them a certain amount of time to serve you with it. Now, service is typically done by a process server, sheriff's deputy, constable, however it is in your state. They literally come knock on the door and they hand you a copy of it. And that triggers the time for you to be able to start to file your written answer with the court. Now, there was a study done of debt collection lawsuits nationwide, and they found that over 95% of people who get sued don't file an answer. The problem with not filing an answer is if you don't file an answer, the court's just assuming you agree with them. They will enter a default judgment against you. Not only that, they give them everything they're asking for, and they usually add attorney's fees, court costs, interest, and that $2,500 lawsuit is now a $10,000 judgment. Judgments, like in the state of Arizona where I live, they're good for 10 years, a full decade that they sit there and churn interest. They can then garnish your wages, levy bank accounts, lien your home, all that kind of stuff. Not only that, in Arizona, they not only can have it for 10 years, they can renew it for an additional 10 years and then on and on and on until the day you die kind of thing. And most states are that way. They have a type of renewal process to the civil judgments. And so if you want to put yourself in the best position you can to get it resolved, you need to file an answer to the lawsuit. That's the first step. If you do that, you have done better than 95% of people who get sued by creditors just by filing that written answer. Now, you may ask you don't know how to do it. Solo has some templates and some tools to be able to do that. You can click on that and kind of check those out. I do that as an attorney. I help people, particularly if you're dealing with a larger one. And there's many of the courts also will have some like a self-help center and be able to help you do that. Of all steps, filing the answer is the simplest of them all. You've got to look at it really. All they're doing is the complaint is the creditor listing out their allegations. The court wants to know, do you admit or deny the allegations of in the complaint? And you just need to write it down and submit it. Now, most courts, whether they're like small claims, justice, superior court, district court, once you file the answer, that sets in motion a bunch of other things. Now, there's these things called the rules of civil procedure. That's what really governs what happens in a civil case like this. Usually what happens next is there's initial disclosures. Both parties have to really show their cards. And that usually happens within about 30 days. They've got to provide you all their documents, their list of witnesses, their evidence. You've got to do the same. And that's really when you can go through and see if they're going to have any trouble. From there, the case may go into a mediation and may go into an arbitration. There's different steps like that and lead us away towards trial. Now, you need to know that the wheels of justice move very slowly in civil cases. For example, here in Arizona, again, where I practice, a case that's filed in Superior Court will not get to trial in less than 18 months. It's just not going to happen. Some of them even go longer. I had a case just recently that was resolved almost 3 years after it was filed. We're finally able to get that thing thrown out. But even in our justice court system, which deals with cases under 10 grand, you're talking about 10 to 12 months to get it squared away. So the main thing I want to leave with you about debt collection lawsuits today is file an answer. If you've been sued by a creditor, make sure you file that answer. That will buy you time to negotiate. That'll buy you time to raise defenses. The worst thing that can happen is you get a default judgment because then all the leverage is gone as far as trying to negotiate that. So if you have questions on debt collection lawsuits, go ahead and throw them in there. I have a bunch from the channel I'd like to dive into, but there's a number of questions here that I want to jump into, some of them bankruptcy related. Okay. Hello, I'm back. LOL. Thank you for being back. Anyway, my bankruptcy Chapter 7 was discharged in April, and I'm still driving my leased car that was included in the bankruptcy Chapter 7. Can I return the car in a few more months? So, good question. So normally when you file Chapter 7 bankruptcy, the debts that have collateral attached to them, secured debts, car loans, home loans, basically the court's going to say, if you want to keep that car, you got to keep making the payment. If you want to keep your house, you got to keep making that mortgage payment. With a lease, it's a little bit different. Leases, you can either assume the lease, meaning you're going to keep it and keep making the payments, or you can reject the lease, meaning you're going to let it go and turn the car back in. Now, sometimes, and we even see this with car loans in bankruptcy, it's kind of crazy. I have clients who are like, I don't want it, come take it. And the lender does nothing. Even after the case is discharged and over, they do nothing. Now, and really, sometimes we have to twist arms for them to take the vehicle back. Not in most cases, but sometimes that does happen. Now, in this situation, if you have a leased vehicle and your intent is to surrender it, which once you do that, you don't owe anything on it going forward, you may want to reach out to, I would recommend you reaching out to the lender and letting them know that you're going to surrender it. If you're driving the car, you need to make sure you have insurance. Not only is it illegal not to in most states, but having insurance will make sure that if there's any problems on the road, you're not liable. Then you can release the car back to the lender and you won't owe anything on it going forward. All right. Awareness Academy says, I won my case because of you. Thank you. Awesome. I'm glad to hear that. Quinn says, once you file Chapter 7, even a week before a court date, does the lawsuit go away? Correct. Yes. So as soon as you file Chapter 7 bankruptcy, one of the most powerful tools of the bankruptcy process is something called the automatic stay. And what that is the automatic stay is as soon as the case is filed, the voluntary petition. You don't even have to file all the documents, just the initial documents. The court automatically enters an order that stays or stops all collections. And it truly is automatic. We filed the bankruptcy cases through the PACER system. It's done electronically. And immediately I can download a document. It's called Notice of Bankruptcy Filing. It has the language of the automatic stay. Stops everything from that moment. That order is actually time-stamped to show the minute that you filed. Technically, you could file, you could wake up, it's time to go to court in 2 hours, file bankruptcy, stops the lawsuit. I wouldn't recommend you wait that long, but I've had clients come in with foreclosures, and it's going to happen the very next day. and we filed the bankruptcy the day before, stops foreclosure sale, stops everything, phone calls, letters, snotty emails, all that kind of stuff stops as soon as you get that Chapter 7 filed. All right, let's see. Evelyn says, I filed bankruptcy in 2010 in California and had an attorney, but the attorney never filed the paperwork to reaffirm the debt on my mortgage. I still have my house mortgage. Is the mortgage company never reports my mortgage. When the reaffirmation was not filed before the discharge, my credit report is not showing that I have a mortgage, and it keeps my score low. My bankruptcy is a 2010 Chapter 7. All right. This question is going to be way longer. The answer is going to be way longer, Evelyn, than you're expecting. Let's talk about reaffirmation agreements. So in the bankruptcy context, the bankruptcy code says, okay, personal property asset like a vehicle that you have a loan against. Bankruptcy code says if you want to keep that car, you need to reaffirm it. Essentially what it is, it's kind of like entering into a new contract after your bankruptcy is filed, where you're saying, hey, bank, hey, lender, I'm going to keep this car, keep making my payments on it. You sign it, creditor signs it. The judge has to approve it. And the legal effect of that is you have essentially, like I said, a new contract that's binding post-bankruptcy. That does a couple things, positive and negative. One positive thing it does, you can keep the car. As long as you're making the payments, you can keep it and continue to use it, and everything's great. You can pay it off like normal. Two, they're required to report your on-time payments to the credit reporting agencies, like TransUnion, Equifax, Experian. They've got to report all that information to the credit reporting agencies to show that you're making those payments on time. The downside is, let's say that the court approves a reaffirmation on your car loan, and then a year from now you lose your job and you got to let the car go back. If they repossess the vehicle and there's still a balance owed, they can sue you for that balance. That's one of the drawbacks to having an approved reaffirmation, where if you don't enter into a reaffirmation agreement on the car, typically state law allows you to keep the car as long as you're making the payments. But in the event that you had to turn the car back in a year from now or a year after your bankruptcy, they could take the car back, but that's it. They can't sue you for the balance. The downside to not having an approved reaffirmation, like on the car loan, is your on-time payments to the creditor are not reported to the credit reporting agencies. And so you're asking, what does it look like on your credit report? It looks like nothing. They're not reporting good or bad. It's just done. And so, Evelyn, that's what you're dealing with your mortgage. Couple things here. Mortgage companies 100% always throw the bankruptcy lawyer under the bus. My guess is, Evelyn, this happened here where you called them up and they said, well, your attorney screwed up. They didn't file the reaffirmation. Mortgage loans, it's typically not required. Excuse me. And I can tell you this, most courts, they're not big fans of signing off on reaffirmations. On reaffirmation agreements on mortgage loans because of that risk that I just talked about. It's amplified when you're dealing with a $200,000, $300,000, whatever dollar mortgage. If they reaffirm that mortgage loan and then you lose your house 5 years from now, you may get sued for the balance. And so I can tell you in Arizona, particularly with mortgages, the courts won't approve them. Even if the creditor and the person who's going through bankruptcy are like, yeah, please, we're all on the same page. The courts will say, no, it's not a good deal. It's a good deal for the bank. It's not a good deal for you. The downside is exactly what you're experiencing. And that is that they don't report any information on your credit report that you're making those payments on time. They're not saying that you are making them late. They're just not reporting anything. And so you're not getting quite the bump you need. I can tell you this is a more complex and annoying provision of the bankruptcy process. This was a change back when they amended the bankruptcy code back in 2005, like when I started doing these things. And to me, it's just been a headache ever since because of the credit reporting issue. I wish Congress would make a change to the code and make it so that they would report those on-time payments. But right now, that's not how it is. So unfortunately, the only kind of workaround that I've seen at this point is you can file a dispute with the credit reporting agencies, with the three bureaus, and provide them proof that you've made those payments. And what they have to do then is reach out to your mortgage lender, and they have to verify whether you made those payments, and then you may get your credit report updated that way. That's not a guarantee, and it's annoying because you have to do it every year to make sure that it stays taken care of. So kind of difficult thing. The reaffirmation thing is a headache. Trust me. I deal with it all the time with clients, and it's something, it's like I said, it's very difficult to explain and go through. And then the workings of that whole, the way credit reporting and lending and repossession, foreclosure, deficiency balances, it all becomes kind of a nightmare. So, all right. Screw it. 999 says, what happens if you file Chapter 7 and there were debts that weren't listed? For example, you forgot about them or something. Okay, that's a good question. So Chapter 7 bankruptcy, it's important that you do your absolute best to list all your creditors. Listing the creditors and providing them notice is often a prerequisite to them being eliminated. Chapter 13 at 100% is. Now, like I said, I'm in Arizona, so the case law that we deal with is out of the Ninth Circuit Court of Appeals. And we have a case in the Ninth Circuit that says, look, if you file Chapter 7 bankruptcy and there's no distribution of money to your creditors, then even if you forgot a creditor, their debt's still eliminated. Basically, the court was saying, look, the only thing they didn't get notice of is that they're not getting anything. However, the situation changes if the bankruptcy trustee in your Chapter 7 sells an asset or takes a tax refund or something and then makes a distribution to creditors. If you didn't list a creditor there, the creditor has an argument that their debt was not discharged because then they didn't get notice of the possibility of actually receiving some money. And so because of that, the debt remains. Now, it's important to know if you file a Chapter 7 bankruptcy or 13, you find about a debt after the fact, but before it's discharged, you can still go ahead and amend to include that debt. So that's what if the case is still open and not discharged, I would recommend amending. They do charge a fee to do that. It's like $35, but I would absolutely recommend doing it. All right, let's see here. Someone says, why is there an income limit to Chapter 7? Example, why can't you make $100,000 and file Chapter 7? Or can you? So there is, and this is part of those 2005 amendments that I talked about, where they went from just kind of, just an individual determination if someone could qualify for a Chapter 7. They went to what's called a means test, where they're looking, man, I'm struggling today. They look at your income and the number of people in your household to determine if you qualify for a Chapter 7. So the idea being, if you make at or below what a family of your size and your state makes, you can file Chapter 7. If you make more than that, the law is saying that they feel that there's enough income there to make some type of distribution to your creditors, and so you should be required to do that. Now, it varies from state to state, and it's updated at least twice a year. But like right now, for an individual in the state of Arizona, where I practice, the cutoff is about $71,000 a year for an individual. However, it goes up depending on how many people live in your household. So for a household of 2, it's about $85,000 a year. For a household of 3, it's about $103,000 a year. My little chart I have goes all the way up to 8. If you have a family of 8, you can make up to $157,000 a year, still file a Chapter 7. So to your question, can you make $100,000 and file Chapter 7? The state of Arizona, you can, but you better have a spouse and a kid or a couple kids or something like that. You better have a household of at least 3. So hopefully that will help. Let's see. Evelyn's saying tea and honey lemon might help. You know what? I have my Kirkland sparkling lemon water, and it's not helping me tonight. I spend all day on the phone and then do this. I always lose my voice. So, okay. Oh, you know what? And Quinn brought up a question. Don't attorneys use a system that lists all debts? So yes, and it is just the credit reports. All attorneys, bankruptcy attorneys I know, we subscribe to a list where we download. I download a report from all 3 bureaus. It doesn't provide me scores or anything, but it does provide creditor account numbers, balances, all that kind of stuff. All right, let's see here. I had a couple more. Oh, Shanita, Big Blue is here. Hello, John. Hope you're well. Doing all well, other than trying to trying to talk tonight. I would like to file a federal suit against a debt buyer and original creditor. What recommendations do you have for me to get started doing it pro se? Okay, the first thing you have to do, federal lawsuit, federal court is a whole different ball game than it's like state court. To be in federal court, there's two ways you can do it. One is the court has jurisdiction over what are called federal questions. You have to be suing on a federal statute, like the Fair Debt Collection Practices Act. If you have a claim against a creditor under the FDCPA, you can bring it in federal court. Or there has to be what's called a diversity jurisdiction, where it's essentially people from two different states are suing each other. You could bring it there. But even then, there's got to be some type of federal question to kind of tie it all in. I would recommend contacting your local federal district court. Most of these courts are going to have like a self-help center or pro se center that will help you in taking that initial steps. You might want to take a look, talk to an attorney too. I mean, the federal court gets very complicated, and I can tell you the judges there, they don't mess around. I mean, they're very strict as far as procedure goes, much more, at least compared to like the Arizona state courts, where they'll kind of let some things slide. Federal court, they don't. So that would be my recommendation. And this question, I'm single, living in Texas, so I can't file Chapter 7. One other thing I can tell you is that when it comes to Chapter 7, the only other exception is if 51% of your debts are business related, then it's something where you may be able to still file a Chapter 7. So the means test only applies if your debts are consumer, not if they're mostly business. But it's got to be, I mean, they take into account mortgages, everything like that. It's got to be over 51%. All right, let's see here. Let's do a couple questions. This is one from the comment section. It said, do the credit card companies always come after you with a lawsuit, or do some just dump it and do collections? Not all of them file lawsuits. I mean, overwhelmingly, there's way more collection accounts than there are lawsuits. You know, the big companies, particularly the junk debt buyers, they have a very sophisticated algorithm. The big companies, the Encore Capitals, Midland Fundings, Portfolio Recovery, they have a lot of data on you that they sift through before they decide to file suit. The dollar amount often doesn't matter. I see lawsuits as low as $500 up to $100,000, but they're looking at their ability to collect, if they have good contact information for you, payment history, if they have banking information, all that kind of stuff. They're going to take a look at that, but determining whether they're going to do the lawsuit or whether they're going to farm it out to a collection agency, that kind of thing. So this question kind of followed along there. Said, my debt with the original debtor expired 5 years ago. Can these junk debt buyers still sue me or collect? Still getting letters. So it's a good question, because there's a distinction between getting sued, where there's a statute of limitations that limits the amount of time that a creditor can file a lawsuit. So example, in Arizona, it's 6 years. 6 years from the time you stop paying, that's when the clock starts ticking, and that creditor, if they don't file a lawsuit within 6 years, they can never file a lawsuit against you. However, that doesn't mean that they can't just still send you letters and ask you to voluntarily pay. Now, if it's a debt collector, the FDCPA says they have to inform you on the collection letter that the time to sue you has expired. So they're just saying, hey, you want to be nice and pay this? They don't really have a whole lot of teeth, to come after you once that's expired, but they can still keep sending letters to you even after the statute of limitations has expired. So, all right, this question said, I'm being sued by LVNB Funding. I went to court to give an answer, and she said it would cost $75 and that I might want to call and see if they want to settle. I called, and the guy said I have to pay the full $933, and they can't stop any legal proceedings anyway. Should I start a payment plan with them anyway, or should I just file an answer with the court? Two things when I saw this question that are kind of interesting. One, clerk of the courts aren't supposed to give any kind of legal advice, but sometimes they do, which is here saying, hey, you might want to call and see if they just want to settle. But there is going to be a filing fee. If you're representing yourself, most courts have a form you can fill out to get that fee waived. If you have an attorney, they're usually not going to grant that. And at a minimum, sometimes even if they don't waive the $75 fee, they might allow you to make it in payments. So, and then the second thing, you call them up and they say they can't stop it anyway. That's garbage. Of course they can stop it. They started it. They can stop it. And especially if you haven't answered yet, they can just withdraw the lawsuit. 100% they can do that. They're just saying that they don't want to. So with something like this, you could file an answer and then try to negotiate a settlement at that point. If it's a junk debt buyer, $900, I would probably say it's going to settle somewhere between $300 and $500. If you can pay a lump sum, you're going to get it done. If you can get it settled before your answer's due, then you won't even have to file any type of response to it. So, all right, we'll follow up here. Oh, this is the one about, that's a scary picture on there, like a zombie picture, saying that your debt's all consumer debt, have to negotiate with creditors. Debt solution services are a ripoff. I tend to agree with that. I know I'm a bankruptcy lawyer, but many of the debt settlement companies, they don't really solve the problem. They kind of just charge you money to make it worse. Your other option is in Chapter 13. Chapter 13 is a much longer process, but it brings a lot of structure to the whole settlement process and makes it so that these creditors are not bugging you. You can force a payment plan on them and kind of get yourself some relief that way. So I always say don't discount Chapter 13s. Have a lot more power than a Chapter 7. They're a lot longer and they can be more expensive, but in the long run, it may be a better way than just trying to negotiate individually. So, all right, we'll do one more with Evelyn here. Just wondering if I could send a dispute letter directly to them on my own, to the credit bureaus, about the mortgage not being reported and send a history of payments. Yes. So if you log on to each of their websites, go to Experian, TransUnion, Equifax, you have to create an online account. It doesn't cost any money to do that. And you can dispute. They have a dispute button right there, and hit the dispute, and you fill out the information. You can even upload documents, like upload the proof of the payment kind of thing. They have 30 days to respond to it. Well, the credit bureau will take it, reach out to the mortgage company. If they don't respond within 30 days, then they have to correct it on your credit report. So let's see here. Hello, John. Sorry, it's been a bit since I've been at your live stream. Great to see you again. Update on LVNB, waiting for an answer from the FDCPA violation case. My attorney filed on June 2nd from service. Awesome. So they usually have 20 to 30 days, so the answer's probably due pretty soon. I can tell you often at the FDCPA, as soon as you file it, if it's a clear violation, they'll reach out and try to negotiate something and get it resolved quickly. So, all right, I think we will... Bad Badger troll account. We'll do one more. I recently received a judgment unknowingly. I caught the 21-day time to file a motion to set aside. Now I want to add evidence to the motion. Can I amend? Well, the question is, if the court has already granted it, you don't need to. But if you want to file that motion to cite, so the way that the rules of civil procedure work in most cases, if you file if you file a motion and the other side has not responded yet, or the time for them to respond yet has not expired, then you can amend it as a matter of right. If they've already filed their response, then you're going to have to get what's called a leave of court to amend it. You're going to have to get permission from the other side. But if you just filed it, and because usually they have a 10 or 14-day window to file a response, if that has not expired yet, yeah, you can go ahead and amend it and add any additional exhibits, anything like that you want to do it. So, all right. I am going to put a link in there one more time. Again, if you're in the state of Arizona, feel free to reach out, set up a consultation. I'd be happy to talk to you. Appreciate everybody checking in tonight. And with that, we're going to end it. We'll check you guys out next week.